New York City Sidewalk Trip and Fall Lawyer, Your Rights. Attorney Andrew M. Stengel. New York City's sidewalks carry millions of pedestrians every day. Many of those walkways are cracked, raised, or broken, and genuinely dangerous. When a sidewalk trip and fall happens in New York City, figuring out who pays is rarely simple. Under New York City Administrative Code Section 7-210, property owners bear responsibility for the sidewalks abutting their land. The City of New York is only responsible for sidewalks adjacent to city-owned property. That distinction matters enormously when you are hurt and trying to understand your options. This post explains who is liable, how deadlines work, and what to do immediately after a sidewalk fall in New York. Who is responsible for New York City sidewalk maintenance? New York City Administrative Code Section 7-210 place sidewalk maintenance squarely on private property owners, not the city. Under this rule, owners must repair cracks, holes, raised concrete sections, and hazards caused by tree roots or settling. Removing snow and ice within a reasonable time after a storm is also their obligation. Property owners cannot ignore conditions that develop gradually over time. Courts find liability when owners knew or should have known about a dangerous defect. A pedestrian does not need to prove the owner received a prior complaint. Evidence of a longstanding condition often establishes constructive notice on its own. However, the City of New York remains responsible for sidewalks abutting parks, public housing, government buildings, and other city-owned property. Identifying the correct defendant requires careful review of ownership records and maintenance agreements. Getting this right from the start shapes the entire direction of the case. The 90-day notice of claim, a hard deadline you cannot miss. Any lawsuit against the City of New York requires a notice of claim filed with the NYC Comptroller's Office within 90 days of the accident. This deadline is absolute. Missing it permanently bars the lawsuit, regardless of how severe your injuries are or how clear the city's negligence appears. Private property owners face a different timeline. New York law allows 3 years from the accident date to file a personal injury lawsuit against a private owner. Even so, waiting is never a good strategy. The Department of Transportation may patch the defect. Witnesses move on. Utility permit records become harder to access with every passing week. Therefore, investigating liability must begin immediately, even before you know exactly who is responsible. An attorney can file a protective notice of claim early while the investigation continues, preserving your right to pursue all defendants. How New York courts evaluate sidewalk defects. Not every crack or bump supports a viable lawsuit. New York courts apply the trivial defect doctrine, which bars recovery for minor, insignificant irregularities. In practice, raised sections of roughly 1 inch or more have been found actionable. Holes, crumbling concrete, and significant unevenness also support strong cases. Documenting the defect immediately after a fall is critical. Photograph the condition from multiple angles and include a measuring device to show the height or depth of the problem. Sidewalk conditions change fast in New York City. A dangerous crack can be repaired within days of an accident. Without clear photographic evidence, establishing the defect's severity becomes far more difficult. Defendants frequently argue the injured pedestrian was not watching where they walked. New York's comparative negligence rules reduce your recovery by your percentage of fault. Courts recognize, however, that reasonable people do not constantly stare at the ground. Occasional distraction does not bar recovery. It may simply affect the final damages calculation. Tree roots, utility work, and other hidden causes in New York. Many dangerous sidewalk conditions across New York trace back to tree roots or utility excavations. Tree roots grow beneath concrete slabs and lift sections over time, creating serious tripping hazards. Property owners remain liable even when city-planted trees cause the damage. The maintenance obligation runs with the land. Utility companies like Con Edison and the New York City Department of Environmental Protection must restore sidewalks after excavation work. When they fail to do so properly, they can face liability alongside the property owner. Reviewing 311 records, permit filings, and utility service records often reveals who last disturbed the area. A gas line repair performed months before your fall may have left the sidewalk improperly settled, and that paper trail can be decisive. Additionally, some sidewalks fall under city maintenance agreements despite abutting private property. Uncovering those agreements requires knowledge of New York City administrative codes and access to agency records that most people do not know how to obtain. Injured on a New York sidewalk? The law firm of Andrew M. Stengel, PC, will act fast. Sidewalk trip and fall lawsuits in New York involve strict deadlines and multiple potential defendants. The 90-day notice of claim requirement leaves no room for delay. Evidence disappears with every passing day, and critical records can vanish before an investigation even begins. The law firm of Andrew M. Stengel, PC, handles sidewalk injury cases throughout New York. Our firm investigates promptly, files all required notices on time, and fights aggressively for the full compensation you deserve, including medical expenses, lost wages, and pain and suffering. All cases are handled on a contingency fee basis, meaning you pay nothing unless we recover for you. Contact us for a free, completely confidential consultation. Email info@stengellaw.com. For more information, please visit our website, stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.